Welcome to Exhuming the Truth, a podcast dedicated to cold cases, missing persons, systemic injustices, and the forensic science that seeks answers when silence remains. My name is Asha, and I am a forensic scientist and criminologist, and in each episode we examine the evidence, the systems, and the human stories often left behind. This isn't just about true crime, it's about truth, it's about accountability, and it's about giving a voice to those who deserve to be heard. Thank you for being here. Hello and welcome, everybody. I hope that you have spent a little bit of time listening to our latest episode, which was a second episode for Corey Fian. I've had a lot of feedback. Most of it has been good, but the ones that have been bad I've loved because they have all been saying the episode's not long enough and other episodes aren't long enough, which I love because at the end of last year, I was actually getting the opposite feedback saying it was too long. So I was like, okay, I'll cut it down. I've obviously cut it too short, which is great because I do always have a lot to say. So I am happily extending each and every episode for you. I did actually record this episode, or well, not this exact episode, but what was meant to be this episode last week. And upon listening back, which I usually do before I obviously upload it when I'm editing, it was rubbish. The quality was just so bad. And that was because I actually recorded from my lounge room and there was just like this echo. So I regret that, but I'm redoing it, which is actually probably a good thing because I've got bits and pieces to add. Now, today we are doing Sarah Spiers part 2. There is a part 3 coming after this, and I actually think there might need to be a part 4 because on our part 1 for Sarah Spiers, we basically just touched base on what the story was and how she fit into the Claremont serial killings time frame, I guess. And today we're going to be going beyond that. But before we chat about that, let's do a little bit of housekeeping here. So in today's housekeeping, it's a tiny bit different because the forensic and criminal justice space in Australia is shifting right now and in ways that actually really matter. So I want to have a little chat about it. Now, across the country, we're actually seeing renewed attention on cold cases as there's advances in forensic genealogy, which we've spoken about before, which is basically like genetics, but forensically testing for genetics. And then we've got DNA retesting, obviously due to new techniques. So these things are opening doors that have been closed for decades, which is amazing. While at the same time, there's obviously serious questions being raised about how evidence has historically been handled. I say obviously because it's obvious to me because I'm reading things every day. You guys probably not so much, but it's a bit of a controversy in the what do we call it? Chain of custody of evidence handling and how that's been done in the past and how we need to be doing that. We're also watching coronial inquests at the moment and post-conviction reviews and kind of shining a light on cases that involve missing persons, First Nations victims, and unexplained deaths that families have been asking answers about for years and years. Forensically, I guess, on top of that, there's growing scrutiny around digital forensics right now, like phone data, theft and geolocation, CCTV, obviously the massive one, social media and crime related to social media. But essentially, I just wanted to put this out there to let you know that there are independent experts like myself pushing for accountability and transparency across the board. This is in advocacy, this is in DNA and evidence handling and what have you. We all know there was a massive issue in Queensland with their forensics and handling, which we have an episode coming out about. But basically, I just wanted to talk about it because all of this reinforces why conversations like this exact one matter, because behind every single headline and inquiry or even forensic breakthrough, there's a real person. And I think the media tend to not post in the victim's favour, which is very unfortunate and it's not exactly ethical, but it is sensational and that's what they want at the end of the day. But we are here for the opposite. We just want to give you the straight up honest truth, and that's what we have done in every episode so far, so hopefully you click in on. But yeah, I just wanted to touch on that. Next, while I'm waffling and I'm allowed to extend my episodes, thank you so much to those who complained, I want to talk about these 2 shows that I watched that I want to talk about, not today, but another time. I just want to put it out there now in case you haven't watched it, and then maybe you will, and then we can have a chat about it, maybe in Sleuth Society. There was a documentary on Netflix, and now I've gone blank and I can't remember what it was called, but it was about Ruby Franke and Jodie Hildebrandt. I think it was called The Evil Influencer, and basically they're a pair of religious women who follow the Mormon, I think it's the Latter-day Saints church, so they're Mormons, and they actually end up abusing Ruby's children through their faith, essentially. They've kind of blamed the faith for the abuse that they have, what is the word? I've lost it. I've absolutely lost it. But anyway, I really want you guys to watch that if you haven't already, because it was really messed up. And if that had me, I was in a chokehold over that. And I have gone to my fiance, I've gone to my mum, you guys need to watch this because we need to talk about it. And then as they were kind of catching up and watching that, I started this other one, which has been on Netflix for ages, and I've kind of just skimmed past it because I just don't really want to watch anything overly religious. And then I kind of read it and I was like, oh, it was called The Sins of Our Mother. And I think the caption said something about, child abuse and the Mormon church again. And I thought, what the hell? Is this a pattern in this religious belief? It so happened to be in the same town where Ruby and Jodie were from. And I thought, I'm going to watch this and see if there's any relation. And that one was even worse than the initial one. And yeah, absolutely insane. So if you haven't watched those two, I highly recommend it, both on Netflix. There's also an extended version on Disney Plus of the Ruby Franke saga. It's actually her husband and her other older two kids speaking on that one. That one was awesome and actually gave better insight. But yeah, that's just what I've been watching. Thought you might like a little recommendation because I really want to talk about it. But let's just get into it. Let's jump into today's episode. We are here for Sarah Spiers again. This is Where is Sarah Spiers Part 2. The facts, the pre-trial, the trial, and what legalities you need to understand. Before we get a little bit legal, please don't shoot the messenger. I am actually a victim of the justice system myself in this country, and I do not have any faith in it whatsoever. And in fact, I despise our system, and I simply can't justify to you why we have laws like we do and why we must jump through so many impossible hoops for basic justice. I have to preface that because I am just going to be explaining to you the laws around this case and how they have been and should be applied and how they apply to Sarah. And this is really essential in understanding where her case is sitting right now. I've called this segment The Scene Setter. Kira Glennon, Jane Rimmer, and Sarah Spiers each vanished after a night out in Claremont Entertainment Precinct, Perth, between 1996 and 1997. The bodies of Kira Glennon and Jane Rimmer were later recovered, but Sarah Spiers has never been found. Despite not being recovered, Sarah has been presumed deceased. These crimes became known as what we know them as the Claremont serial killings, and this series of events gripped the WA community, instilling fear and demanding answers for over 2 decades. Come December 22, 2016, and Bradley Robert Edwards was arrested and charged under Section 278 of the Criminal Code WA with the willful murders of Jane Rimmer and Kira Glennon. Come 2018, and he was additionally charged with the willful murder of Sarah Spiers, but he actually entered pleas of not guilty in regard to all 3 charges. Now, for Bradley Edwards to be found guilty on each of these charges individually, the state has to prove beyond reasonable doubt 3 things. That he killed the named persons, this is known as the actus reus. That the killings were unlawful, and that he intended to cause their deaths, and that last one is also known as mens rea. Now, just to further that explanation, so we're all on the same page, when we're talking about the actus reus, this is just the physical act of carrying out the crime. So in doing so, this has to be a voluntary act. So that just means that he did it, out of his own will. Now, the mens rea actually refers to the mental state of the person committing the crime. So Bradley Edwards, his mental state, and essentially This translates to a guilty mind. So to be convicted of willful murder in WA, the offender has to have had the intention to cause the death of the victim or victims. So let's jump into the next little segment called the legal stuff. It's not very professional, but it is what it is. I want everybody to understand what I'm talking about. So this is a really bizarre rule that applies to every Australian jurisdiction except for Victoria, ACT, Tassie and the NT. Now this rule basically says the person who is accused of a crime or the state itself can elect to apply for a judge-alone trial instead of having a jury. This is just absolutely wild to me, but anyway, this is a rule that is actually a constitutional right under Section 80 of the Australian Constitution. And what does this mean? It's just a little personal footnote, essentially, but after going through it myself, I am of the opinion that in any state in Australia, the prosecution, which is the victim's side, should be able to choose if they want a jury or not. One, because it's their life that's being scrutinised and put on show. And two, because what the actual fuck is the point in having a legal professional by the way of a judge if he or she is not the one applying the law? Like, it blows my mind. You can tell the jury, discard this. You've just listened to this for half an hour, but discard that. You can't include that in your ruling. Or this is how the law works here and this is how you apply it, and you can't apply your emotion and only legal logic. They can say that 500 times. But they will always, and they, I mean the jury will always act with personal bias on any and every level. It's human nature, but a judge cannot do that, and they are trained not to do that. That's just my little piece to add, so let's move on. I'm getting stressed, and it's reminding me of my own court case. They do this usually, so the selection or like opting in or out for judge-only trial, they usually do this when there's like a high-profile case. And that's when the case has kind of been in the media, so they're worried about it being impartial to the jury. So they're worried if the jury have read or seen bits and pieces and kind of already made up their mind, and they just want to ensure a fair trial. So in this case specifically with Bradley Edwards, they identified 4 separate reasons for why they could, why this case would fit that requirement and why they wanted to be heard by a judge only. And those reasons were the extent of the pre-trial publicity, obviously, because it was across the news, the likely length of the trial, because it was going to be, quite long, and then the graphic nature of the evidence and the technical or complex nature of expert evidence proposed to be presented. So obviously, if it's very complex expert evidence, we don't expect an everyday person on the jury to understand or know how to process that information. Again, this is why we have judges, but anyway. So in this circumstance, it was the prosecution who applied for the trial to be heard by the judge alone, and they did that under something called an order under Section 118 of the Criminal Procedure Act 2004, which is obviously applicable to WA because that's where it was held. Now, the defence obviously had to agree to this decision, and then the order was approved. So the trial goes ahead, and they've assigned Justice Hall. He is the judge, and he is now responsible for ensuring the principles of the law and procedure are applied, and he's also in charge of making the end findings after all of the evidence has been showed and spoken, and then lastly and importantly, handing down the verdict based on all of the factors that we've spoken about. So who is Justice Hall, you might be asking, or you might not, but I'll tell you anyway, because it is important about what judge you get for what case and how they apply the law. And Justice Hall is actually very well known to be a very methodical judge in the way that he is very legally orthodox as a trial judge, and he's very strict in his adherence to procedure. So they say, and I quote, very retrained and unemotive. That's how he's been described in the past. I'm sure if you jumped on the internet, there's really no lack of reading about the victims' families and how they feel about Justice Hall, and the public being frustrated with his decisions and perhaps the way he carries such a tight leash, I guess, with the procedural boundaries. Hall's courtroom for this trial was not a space for closure. It was more a space for legal scrutiny, and while the restraint can feel cold, it said that it does allow a verdict to withstand time and appeal, if that is any consolation. I'm not sure, but yeah, he's a very strict judge. So let's get into the next segment. It is called The Trial, and I'm going to break down that trial for you and everything that kind of happened as quickly as I can so we can get moving. So when it comes to the trial of the Claremont serial killings, the prosecution had to rely heavily, if not entirely, on DNA and propensity evidence. Now, I'm going to explain that to you in a moment. DNA obviously falls under forensic evidence, and when we talk about propensity evidence, we're talking about a person's character or their habits and what kind of movements they do and like their routine. Propensity evidence is actually a type of circumstantial evidence, which usually isn't accepted unless it's paired with other solid evidence like DNA. The DNA evidence that was solid was finding Edward's DNA under the fingernails of Kira Glennon. Now, with this evidence, the prosecution tries to argue not that it wasn't his DNA, which was an impossible argument, but that his DNA got under her fingernails during a violent struggle before her death, but common sense prevails here, and Justice Hall accepts this forensic evidence as a very vital piece of evidence against Edwards, not for him, and in doing so, he accepts the DNA being that of Bradley Edwards, and then he also accepts the argument for how it got there. I think I said the prosecution tried to argue that it wasn't his DNA. That's wrong. The defense tried to argue. Sorry, I messed up. The defense, is obviously working for Bradley Edwards and trying to defend him and his innocence. Sorry, I'm trying really hard to run through this with the essential information while also breaking it down for you so it's easy to follow, and I've probably confused you there, so I apologize. After this, we have the prosecution with forensics, this time in the form of fiber evidence. And a little, attachment to this is my old teacher at uni was actually the one who found the fiber evidence in his vehicle. Now, the fiber evidence was when they had found that Jane Rimmer and Kira Glennon had been in a VS Holden Commodore vehicle, which was the vehicle driven by Telstra employees, and Edwards was a Telstra employee at that time. So in their argument with this fiber evidence, they argue that Edwards drove the car where the fibres were discovered, and this argument was also accepted by Justice Hall, which is great. Now, the issue we have here is we have 3 women, all unsolved cases at the moment while it's in court, and all in similar circumstances. But with 2 women, we've recovered their bodies, and we were able to have actual forensic evidence to tie down that propensity evidence. But with Sarah, we have the propensity evidence, and then, of course, because she has not been recovered at this stage or even now, we're unable to solidify this and, pair it with that forensic evidence, which, of course, is what holds the main weight in a courtroom. So the pairing of this propensity evidence and the forensic evidence for Kira Glennon and Jane Rimmer is described by Justice Hall in court, and he says, having regard to the DNA evidence, the fiber evidence, and the propensity evidence, I am satisfied beyond reasonable doubt that the accused was the killer of Jane Rimmer and Kira Glennon. Now, this is a fantastic result for these 2 women, but where does it leave Sarah? And that's what we're here for. And we have now a situation where they're deeming her to be deceased, right? So they've ruled Sarah as deceased, and the prosecution are making the case to Justice Hall saying that even without recovering her body, we have similarities here between the circumstances of her disappearance and the death of the other 2 women, and all of these similarities are incredibly close, but he takes that in, but he says he's unable to logically conclude that Sarah was killed by Edwards too. Now, because he disagrees with this argument and says that the similarities are actually more general in nature, and goes even further to say that there's actually fewer similarities in Sarah's situation than there are in Jane's and Kira's. So he says, therefore, he cannot conclude beyond a reasonable doubt that Bradley Edwards also killed Sarah. Now, after this, Edwards is actually sentenced to life and was given a non-parole period of 40 years, which was handed down in December 2020. So this took quite some time. Now, our next little segment is called the application of rule of law of principles. I'm not even going to explain that because the segment explains itself. It's basically how this happens. Anyway, let's get into that. We have something here called the presumption of innocence and the burden of proof. And in every criminal trial, the key starting point is that the accused person, so Bradley Edwards, is presumed innocent until proven guilty, and then the onus of proof lies solely with the prosecution. So basically, walking into that courtroom, they assume he's innocent, and it is up to everyone else to prove otherwise. So Justice Hall actually said, an accused person does not have to prove his or her innocence. Indeed, he or she does not have to prove anything. The onus is on the state from start to finish. It never shifts to the accused. So what this is saying is the standard of proof that the prosecution must meet in order to prove that Bradley Edwards is guilty beyond reasonable doubt is the highest standard known to the law. So this high burden of proof reflects the important principle of Bradley Edwards because he's entitled to being presumed innocent until obviously he was not cleared of Kira and Jane. However, he has been cleared of Sarah, so he has been presumed innocent there. Now, Justice Hall also said the accused was presumed innocent. The state bore the onus of proof, and the standard of proof was beyond reasonable doubt. This is obviously in regards to Sarah only. It is only if all elements are proven beyond reasonable doubt that the accused can be found guilty of a particular charge. Now, he obviously, like I said, was the judge found Bradley Edwards not guilty of Miss Spiers' murder, even though he did conclude that the accused was guilty of the other two murders, and I can see this is incredibly frustrating, especially since they kind of took in all the similarities when it came to the other two women, and they actually admitted that propensity evidence as evidence. And a lot of the time in a criminal trial, they don't do that. They'll say, that's circumstantial, you can speak about that, but we're not going to accept that. And this is problematic because they have two women who have been murdered and found, and they had DNA and forensic evidence. Not a lot of it though, but it was mostly essentially the propensity evidence that tied the two together before they were able to find and solidify the forensic evidence. So it was a big shock to WA that he didn't get charged for Sarah's murder because they had ruled her deceased, and here we have such strong similarities, even though Justice Hall says no, the similarities were not that close together as Kira and Jane's. Well, they're very similar, and the fact that they tied those two women together already before finding any forensic evidence tells you that they kind of I don't like the way they've done this, because they've accepted propensity evidence without DNA basis, but they've kind of rejected it for Sarah. And I don't love that. I don't love the outcome. And again, I've spoken so much about it recently because I feel like it's just more cases are having this issue where the lack of evidence is an issue. And I am going to do a big, quite a large segment on pattern evidence and how we can actually, while pattern evidence is typically circumstantial evidence, how that can also be tied to criminal profiling, which is solid evidence. We're going to do an episode on that. And talk a lot about no-body murders. That is what I specialised in overseas, was missing persons and no-body murders. And I want to talk about no-body murders in Australia because that's essentially what we have here. We have Sarah Spiers, who's been ruled deceased, and we don't have any solid evidence, and we don't have her body. Now, the evidence, the lack of evidence, the pattern evidence that we will talk about, and the missing body fails to meet the legal thresholds here, which gives her family essentially zero hope for the future because we have such ridiculous thresholds that they're just not going to follow through. So I'll start briefly on this segment called No-Body Murders in Australia, and I'll just let you know a little bit about that. I don't want to overload you too much in one episode and you'll walk away brain dead, so we'll finish up shortly, but I want you to know what the law allows when it comes to no-body murders in Australia and what it still doesn't allow or what it resists. So when people hear the phrase no body murder, the assumption is always no body means no case. This is absolutely not the case. That assumption is wrong. But the reality is very, very complex. Now, in Australia, it is legally possible to prosecute and convict someone of a murder without a body. I have an example at the top of my head. We have Hayley Dodd and we have Frank Walk, who's been convicted of her murder, and we do not have her body. Now, the evidentiary threshold is very, very high for no body murders in Australia, and that's a deliberate act from the justice system. Now, that's to safeguard any exits and to prevent wrongful convictions where death itself cannot be conclusively established. So it is possible. It's very difficult here. It is a lot easier in Europe. In Australia, not so. Now, what do we need to prove to convict somebody of a no-body murder case like this? In a standard homicide prosecution, the prosecution has to prove beyond reasonable doubt, like we spoke about, that a person has died, the death was caused unlawfully, and the accused was responsible. But in a no-body case, that first element being proof of death must be established entirely through circumstantial evidence. So this is where the legal system just fucks me over in like every time I think about it, because before here we have this trial and we've thrown Sarah and her case with Bradley Edwards out the window because all we had is circumstantial evidence. But in a no-body case, which is exactly what this is, we have to rely 100% on circumstantial evidence to determine whether she has died or not. And it just doesn't make sense to me. Anyway, courts require evidence for this, that the person is truly deceased and not merely missing. So they've ruled that. They've said she's deceased. Now, the circumstances exclude reasonable alternatives like voluntary disappearance. They've excluded that. The death was not accidental or natural. I'm unsure. I think they've excluded that, but I'm not 100% sure. And then the accused has had the opportunity, the motive, and the connection. So his connection here would be under propensity evidence and circumstantial evidence. Obviously, there would be nothing solid. Like we said, no body murders in Australia rely entirely on circumstantial evidence to prove that she is no longer alive. Now, this is why no body prosecutions are rare in Australia. Overseas, not so much. But in Australia, yes. Not because they're impossible, but because courts require the case to be airtight. Like, there are no exceptions. That's why Justice Hall, because he's so strict, he's just like, no, if I can't, have it black and white, I don't want it at all, essentially. And so obviously, like we said, with Hayley Dodd and Frank Walk, no body convictions do exist in this country. A couple of other murder cases at the top of my head, we have Baden Clay in Queensland, we've got Edwards in Victoria, and Munro in New South Wales. And all three of these cases relied on forensic reconstruction. So that's what I was talking about before. We can absolutely take this circumstantial evidence and try and reconstruct something that has happened. There's obviously digital evidence, which is not big in this case because of the time. Behavioural evidence of both Sarah and Bradley Edwards, and lies and inconsistencies that would apply to Bradley Edwards, and then demonstrable post-offence conduct. Sorry, I don't think I even said that right. Anyway, so how he's behaved after he has committed this crime against Sarah, if he has. And crucially, none rely on absence alone. They all rely on what replaced the body as proof. So next time we jump into part 3 for Sarah, I'm going to talk in length about pattern evidence and how important it is in this case. We're going to talk about the hope for Sarah for the future, and a little bit more about Sarah herself and what kind of patterns she could have been following at that time, and how we can apply all of this to Sarah and her case and hopefully keep the case alive. But yeah, thank you so much. I know this has been a bit of a different episode because this is such a complex case. And there's a lot to know and understand in order to understand why someone wasn't convicted, how they can be, and things like that. So I hope I've made that clear for you. I know I messed up a few times today, but I did my best. And yeah, a no body murder prosecution is not impossible in Australia. But like I said, it just, the evidence that replaces the body is circumstantial, which, blows my mind. But anyway, patterns can tell us where to look. they can't by themselves tell us who to convict, but, we have been through a whole trial with this man, and there's certainly always a possibility. So I'd like to keep that possibility open. And I appreciate you guys so much for requesting further episodes and requesting for episodes to be longer, because we know I love to have a chat and go in right deep down into things. I feel like that's what we've done today, and I feel like I may have been a little bit too legal today. It's not my favorite thing to do, but it is always important in cases like this. So we had to get that out of the way, but let me know if that makes sense or if you have any questions. Thank you so much for being here. I hope you have enjoyed it. And if so, you can join us across all social platforms and on our new Facebook group, Sleuth Society. Have a beautiful day.